Welcome to Polypulse, your daily South African political pulse. Today, the Madlanga Commission is back in the spotlight, and there are fresh revelations about state capture that you need to hear. Stick with me for the breakdown. Here's what's happening. Click, like, and subscribe. Roll the clips.
They responded and said, but we're not there because that's a virus issue and we're not talking about
that. There can't be a rebuttal witness in the sense I was talking about if there has not been an assessment by that doctor.
And that's where I said I respectfully disagreed with that. Remember, that's the first thing I said is I disagreed with that characterization at the beginning.
I just wanted to make sure, that because it seems you misunderstood me.
I didn't misunderstand.
I was talking rebuttal after an assessment by that rebutting doctor.
And I immediately responded and said, I'm not sure I agree with you in that regard.
Can you move on to your next point?
No, that's fine.
Please?
I was just setting out then the basis for my disagreement with you, Chair, respectfully, about how that mechanism is going to work. I don't have to take it further.
We can't force him. We agreed, and which is why I'm talking about the criminal process that the Commission is minded
Exactly
to.
the point, Chair.
Yes.
Exactly the point, Chair. So that is available. May I just then speak to what the Commission says is the way forward? Chair, you'll remember that in its letter, I'm going to read from page 119 of the correspondence bundle, but as far back as the 24th of June 2026, this is the Commission's letter to my attorneys. At paragraph 12 is exactly what the Commission says today is the way forward. Obviating the need for a medical exam.
Evidence leaders, Mr.
Evidence leader,
I
apologize.
Don't confuse what the evidence leaders say with what the Commission.
I apologize. The evidence leaders, and I don't want it to sound like I'm
They say in the circumstances, the evidence leaders will proceed as follows.
Yes. So, and that was. You'll remember that was on the 24th of June, and then I think we were in front of you. Was it the 1st of July? And then there was an exchange of correspondence, and this medical exam issue arose after this letter. But in response to that particular letter at paragraph 12, came our letter, which starts at page 121, which says, yes, if that's what you want to do, that's what you must do. And so insofar as Ms. Hassam says today, the evidence leader says today, that this is the position of the Commission and
Of the evidence
leaders, I apologize. Ms. Hassam says that this is the position of the evidence leaders. We understood that to always be the case from that page previously, and we've never taken objection to that, which is why, Chair, you'll remember in that debate that we had, I think, that the transcript refers to, when you and I were discussing the adverse findings that were to be made, my response to you was that yes, that's the ordinary way in which evidence will be dealt with, and if it's unanswered, you'll draw the appropriate inference, you'll draw the appropriate credibility finding, and that's the risk that my client was always subjected to, and that's the consequence he must face. So if that's the Commission's attitude today, consistent with what they previously said on the 24th of June, in that debate with you, Chair, you'd remember I said I can't commit my client to a position, but I explicitly said to you I could not fault that that's the end point we'd come to. So to the extent that's the evidence leaders, Commissioner Kamalo, to the extent that's the evidence leaders' position in front of you today, I accept that position. In fact, and not to be flippant about it, we were already here a month and a half ago, and only as a result of the Commission's extension and the possibility of a medical exam did all of these issues arise all over again. So in fact, we're now going back to the position that we were in late June, and with all due respect, the Commission, but also sometimes the evidence leaders complain that the Commission is running out of time and there's no guarantee of an extension. So we're back to where we were on the 24th of June. The Commission and or evidence leaders will do what they do, and we'll deal with the consequences. Lastly, Chair, on the issue of the possible recommendation of criminal sanction, whilst you've got the letter I referred you to starting at 121 in front of you, it's just a few pages on from the Commission's letter at paragraph 12 that we were dealing with. If you could please go to paginated page
124.
124, yes, indeed. That's the request.
Again, Commissioner Kumalo.
Thank you, Chair. I'm indebted. Particularly paragraph 11. If such a recommendation is going to be made, then on that specific question about whether criminal charges should be recommended or not recommended, all I'll say is that our client, as far back as the 24th of June, asked that if such a referral was going or recommendation was going to be made, that he be given the chance to address specifically that referral decision, consistent with authorities like Dupria and so on. And also, because that's an Audi issue, we say respectfully, and particularly to place in doubt the question of willfulness and whether or not such criminal charge is competent and viable as against my client.
Aren't those issues, that is the issues of willfulness and so on, issues that should actually arise before the relevant criminal authorities, if that referral does not get killed at the level of SAPS or at the level of the NPA, they may then be dealt with by the criminal court. So I'm not sure I get your point.
What I was going to say, and then rightfully I showed deference to the chair, is that on that particular point, about Audi in front of you before the recommendation, I was going to say that's not the hill I'm going to die on, because it might be correct that you can make the recommendation being recommendatory in nature without ticking the box of direct external legal effect as well as adverse consequence, that you even owe us the right of Audi at that stage, because the correct decision-making functionary is where we'd have the ability to make those representations anyway. So what I was going to say to Chair is that the request is in front of you. You may choose to say no, which is fine. I'm just saying that the request is there. That's all
we are all here now. Make whatever submissions you have in mind in this regard, so that we are done. It's done and over with.
Thank you, Chair. May I just make 3 submissions in this regard then? Number 1, the test would be willfulness for any such breach or non-compliance. We say that the threshold is not met, having regard to the medical evidence that is in front of you, and which is unchallenged. And I know that that's sensitive territory, so I tread lightly. That's the first point. The second point is that the point about that evidence being unchallenged, so to speak, and where non-compliance is as a result of medical advice as a valid and legitimate excuse is actually something recognized by the foreign authorities that my learned friend Ms. Hassan handed up at the last hearing. You'll remember I was going to do an audit of those authorities, and then Chair intervened and said, no, maybe we can leave those authorities, and we did, and I never went on to those authorities. But can I just give you the single reference to the one authority, please, that is in my learned friend's bundle, and I just want to point it out because I say that that's the second basis upon which we're entitled to utilize that as a valid excuse for non-participation. And if Chair will just bear with me, I now need to find my own papers. Yes, it's the authority of Wandsworth. The full citation is Tainaz versus Wandsworth, square bracket 2002. It's the England and Wales, I think it might be Court of Appeal, EWCA. No, it's the administrative court. I apologize. EWCA Civil Division 1040. At the bundle that was given to you by my learned friends, you'll please look at paragraph 21, where the conclusion reached by the court in that regard is that where a litigant was unable to attend through no fault of his own, must usually be a...
And that's your PolyPulse brief for today. If this helped you make sense of the madness, smash that like button, subscribe, and hit the bell so you never miss a breakdown. For more South African stories from a youth perspective, check out our sister channel at Mzansi Pulse. I'll see you tomorrow. Stay sharp, South Africa.